The Clayton Act of 1914. Industrial powers were generally able to avoid the Sherman Act of 1890. For example, in the 1895 case of United States versus E.C. Knight, 156 U.S. 1, the Supreme Court refused to break up the so-called Sugar Trust, even though the American Sugar Refining Corporation had gained 98% control of the American sugar refining industry through various acquisitions and agreements. In an 8-1 decision, the court decided that refining and other kinds of manufacturing are inherently local activities. They reasoned that the plant exists only in one state, and therefore, unlike distribution, manufacturing generally could not be subject to the Sherman Act, because that federal statute related only to interstate commerce, not to intra-state activities. So instead of hitting its intended target of industrial magnates or so-called robber baron capitalists, the Sherman Act was used against labor unions. For example, in United States versus Working Man's Amalgamated Council of New Orleans, 54 F 994 from 1893, a court in Louisiana's Eastern District found that a merchant union strike illegally arrested the flow of commerce through New Orleans. Although the strike occurred in New Orleans, it restrained the interstate and foreign commerce which flowed through that city, and therefore was criminally prohibited against the Sherman Act. In 1914, Congress sought to rectify these defects. First, Congress passed the Clayton Act of 1914, which clarifies the Sherman Act and elaborates on specific illegal practices that constitute monopolization. Let's talk about a few of those specifics. Section 2 of the Clayton Act prohibits price discrimination, which is where a seller sells the same good at different prices to different buyers, where the effect is to substantially lessen competition or to create a monopoly. Price discrimination sounds bad. It has discrimination in the name. But it's not necessarily bad. It's actually quite common. Any time a customer uses a coupon, that's probably price discrimination. For example, McDonald's is trying to encourage customers to place orders via its smartphone app instead of via its counters. To do this, McDonald's offers daily mobile-only deals, such as 2-for-1 hamburgers. Two different customers go to the same McDonald's on the same day and order the same thing, 2 hamburgers. The customer who placed the order via the app pays half as much as the customer who placed the order in store. This is price discrimination. Price discrimination is prohibited by Section 2 of the Clayton Act only where it substantially lessens competition or tends to create a monopoly. Section 3 of the Clayton Act prohibits tying, bundling, and other specific ways that dominant firms can use their market power in one domain to extract rents in another. Bundling occurs where a firm sells 2 or more products at a single price. If you've ever bought a basket of apples, you were in bundling. Tying is a specific case where a particular firm sells a particular item only with some other item. Tying is thus a special case of bundling, where consumers do not have the choice of buying a tied product without the tying product. Tying can be efficient and unobjectionable, but Section 3 of the Clayton Act provides a cause of action against monopolistic tying of goods. Courts generally found that the Clayton Act only prohibits tying of goods, which are things that are identifiable and movable at the time of sale. The Sherman Act, which is broader, is employed where plaintiffs and prosecutors want to enjoin tying of services or intellectual property. In addition to prohibiting tying, Section 3 of the Clayton Act also prohibits exclusive dealing, which is a type of vertical restraint. So let's take a moment to compare and contrast horizontal versus vertical restraints. First, both horizontal and vertical restraints deal with multi-firm conduct. Single-firm conduct, known as monopolization under Section 2 of the Sherman Act, is neither horizontal nor vertical. Single-firm conduct is like a single point, whereas you need multiple firms acting together to have a line. Whether that line of multi-firm conduct is horizontal or vertical depends on whether the firms are competitors or whether they operate in different parts of the supply chain. Horizontal restraints involve agreements among competitors. The Standard Oil Trust Agreement is an example of a horizontal restraint because it involved different oil distributors agreeing to limit output which, by the way, is exactly what OPEC does today to control the price of oil internationally. A vertical restraint, on the other hand, involves parties who are already in a supply chain relationship with each other. As an example of a vertical supply chain relationship, consider breakfast cereal. Kellogg's makes Raisin Bran. To make this product, Kellogg's purchases raisins and bran from suppliers. Kellogg's also purchased cardboard boxes to package the cereal. The raisins, bran, and boxes come from upstream suppliers who are above Kellogg's on the vertical supply chain relationship. And then to distribute the product, Kellogg's sells the packaged cereal downstream to supermarkets and grocery stores like CVS, Kroger, and Target. CVS, Kroger, and Target are downstream purchasers who are below Kroger's on the vertical supply chain relationship. And meanwhile, Kellogg's has horizontal competitors, companies who also produce Raisin Bran. These horizontal competitors may have their own suppliers and their own distributors. Post brand Raisin Bran, for example, is made with Sun-Maid raisins. If Post has an agreement with Sun-Maid raisins to the effect that Sun-Maid may only sell raisins for bran cereal to Post, that is an example of exclusive dealing. Again, exclusive dealing only regards vertical supply chain relationships, such as between producers and distributors. Exclusive dealings are only illegal where they have the effect of substantially lessening competition. In this case, it does not appear to be the case that Kellogg's has any problem getting food-grade raisins for its Raisin Bran cereal because Post has exclusive dealing with Sun-Maid. Therefore, this exclusive dealing probably does not violate Section 3 of the Clayton Act. Section 7 of the Clayton Act prohibits certain mergers and acquisitions that may substantially lessen competition. This overlaps with Section 1 of the Sherman Act, which likewise prohibits combinations. And Section 8 of the Clayton Act prohibits so-called interlocking directorates. Interlocking directorates are where one person serves as the director on the board of two or more companies who are competitors. Interlocking directorates are illegal under Section 8 of the Clayton Act only where those competing companies would violate Section 7 of the Clayton Act by merging. Some interesting questions today include whether board observers who attend board meetings and have information rights but who do not vote on corporate decisions can violate Section 8 of the Clayton Act. These questions recently became relevant by the activist Federal Trade Commission, who enforces the Sherman Act and the Clayton Act and recently suggested it would increase its policing of interlocking board behavior. This leads us to our next topic. Who is the FTC? How did this Federal Trade Commission get started? And where does its antitrust enforcement authority come from?